this case, in this section, it's shown about the remedies available to copyright owners. The remedies available includes damages, whereas it's compensation, also an injunction, so you're stopping the person from the line of business, and also seizing infringing copies of suit. That can include copies in physical form or in electronic form, in any kind of form that maybe they've taken that product and changed it to further their benefit. In this section, it shows section 12, duration of the copyright and how it can be beneficial to the copyright owner. Obviously, if the copyright ownership is for the lifetime, however, they've got 70 years, so that they've got their protection. No one can claim their goods even after their lifetime, so this is beneficial. So you're holding your creation that you worked hard for, so that way you're fully protected for those 70 years. So it's beneficial to you to protect and register your goods. Now I'm going to hand over to me, that will explain further on copyright user. What is a copyright user? A copyright user is an individual from the public who wishes to use the copyrighted works. There are two types of users, which could be classified into different parts. The users that uses the copyrighted works for commercial purposes, and those who wishes to use the work for non-commercial purposes. Copyright users, the copyright users that have the purpose to use the work for commercial use have to gain license from the owner before using the work, and or they have to get permission from them if they have the intention to use the work for commercial in a commercial way. They have to get a license or permission from them before using the work. In relation to this, a copyright user exercising to use the works in a non-commercial way, there are a number of committed acts covered under the section 28 to 76 of the Copyright Act 1988. Copyright user permitted, which is identified by the legislations, is the making of temporary copies of the work. In the section 28 and 28A of the Copyright Act 1988 states that the making of the temporary work, which is transcend and basically temporary will not be infringed. Will not be infringed if either the transmission of the work between the third party by like an agent, or if it is like a lawfully used for the work. And it also says that it provides acts carrying no economic value if it will protect the user. The purpose of in section 30 of the Copyright Act 1988 states that the work has to provide to the public, and it's basically acknowledged by the copyright owner. This will not be infringed upon the user, and also states that the fair dealings of the work through a process of reporting recent events will also not be infringed on the copyright, providing it is not
providing it is not met as with an acknowledged. In this case of Ashdown and Telegraphic Group Limited, basically they had a meeting with the Prime Minister and Lord Ashdown with some other political party. It was told by the editor of the press that the meeting should not be publicized, but he made it public anyway. He went back and put it on the papers. So Lord Ashdown basically filed a lawsuit on the newspaper saying that it should have been private, because he wanted basically to write it himself, not somebody else writing it. So basically he filed a suit saying that it should have been private. So it was a breach of copyright and a breach of confidentiality. One of the most important users is identified and protected by the legislation of the copyright within the education. Section 32 to 36 of the Copyright Act 1988 states that the work is not infringed if is being used within the course of instruction for educational purposes. Whoever is going to give the instruction for this issue is a person who receives a professional instructions themselves, and work is met within the acknowledgement. Another vital area of legislation which protects users in relation to the library is basically in libraries, and in section 37 to 43 of the Copyright Act 1988 states that a prescripted library should be able to make copy work without them being infringed. And however, this provides a copyright. This provides a copy of suppliers that individual uses for private and only research purposes. Basically, maybe students can go into the university and use it. It doesn't have to be someone that is going to use it to make a product or something to make commercial use out of it, to basically make sales or something. It should only be for studying and for private studies. And if section 44 of Copyright Act 1988 goes further to state that libraries are able to lend out copies of the work, provided that it is within the United Kingdom, so they can't go out maybe to America or to Japan or to another different country to provide the work, the copyrighted work. It has to be within the UK, and also, like I said earlier, it has to be for only for students or for private work. It doesn't have to be for somebody that is going out there to make it for work, maybe to go and research for a laptop, to go and make a laptop and sell it. Because in that way, the work is being infringed.
Okay, so now we've spoken about both the copyright owners' interests and how they're protected, and both the users' interests and how they're protected by legislation. We feel we've come to a good conclusion. We feel there's a slight imbalance, but it is right. If you create a copyright, you should own more rights for it than the users. But obviously, in address to the question, we feel that there is a slight imbalance towards, more in favour of the owners, as the seesaw shows there. Because the owners, they can lend it out. They can do with it what they please. Really, the users are restricted to only a few things, and there's only a few scopes as well. That's what we feel as a group, that we feel the owners have more of a right than the users. Okay, so that concludes it. So thank you very much for listening. If you've got any suitable questions, then we'll be able to do our best to answer them for you. Thank you.
Well done.
Any questions?